Hello, everyone. I'm Stan Yukovich. I'm a corporate partner with Morrison and Foerster in Tokyo. Thanks very much for joining today, and welcome to our lunch webinar on national security regulation of cross-border strategic transactions. And our focus today is on national security regulation of transactions in the United States, the EU, and the UK. And to that end, we have regulatory attorneys, our experts in our Washington, D.C. office, our Berlin office, and our London office. They will all be presenting. As we all know, this is a mission critical area. Pretty much every transaction that we work on with our Japanese clients outside of Japan, we look at national security issues. It's a mission critical area. It's also a rapidly changing area. It's very important that we all stay on top of current developments because the area is changing a lot. It's becoming stricter and it's becoming more global. So to that end, our team today is very happy to present you with updates and insights on important factors to get your deals cleared, to stay on timing, and to succeed in your cross-border M&A transactions. So very happy to have you all here today, and we're all looking forward to today's presentation and some discussion. I have two administrative points. First is Q&A. We welcome your questions during the presentation. We have the Q&A function is open on Zoom, so please feel free to send us your questions during the presentation. We don't have a Q&A session scheduled. This is a lunch webinar, and it's pretty packed with content. So we're going to take the hour to present, but we will make an effort during the presentation to respond. And if we don't respond during the presentation, then we'll follow up with y'all directly. Also, please feel free to contact any of us with your questions during or after the presentation. Our contact information is on our website, and also we have bios at the end of the presentation deck. Second admin point is for those of you that are licensed attorneys in New York or California, 1 hour of CLE credit is approved for the seminar. I'm going to announce the code for the credits at the end of the presentation. So please stay for the whole presentation so you can get that credit. I'll be passing on the code. Also, we'll be sending a link to the application website to apply for that credit. So without more from me, I will turn over the webinar to our team from Washington, D.C.
Thank you, Stan. My name's Charles Capito. I'm a partner in MoFo's Morrison Foerster's Washington, D.C. office. I'm joined for the U.S. discussion by my colleague James Brower, also in our Washington office. And then I'll be handing it off to Felix Helmsteiner in our Berlin office, partner in our Berlin office, to talk about EU developments in this space. And then Mary Claire Strawbridge in our London office to talk about developments in the United Kingdom. Felix, Mary Claire, and I and others in our group had the pleasure of being with many of you in person last year, and regret that we cannot do that again this year, but are glad to have this opportunity to present on similar issues. I think you'll see that as Stan previewed, the issues continue to evolve. There have been some significant regulatory developments in all of these jurisdictions that we will touch on in some detail, and some will have to, given the time and nature of the presentation, have to gloss over. But as we do encourage questions either during the course of the presentation or as follow-ups. If we could transition to the next slide. So just to level set on how we think about a national security practice, and specifically as it affects cross-border transactions, it's really a multifaceted set of skills and set of experiences, both in terms of the geopolitical issues that we are faced with evaluating, but also with and then with the regulatory regimes that that affect those geopolitical issues. And then more recently, it used to be that these were fairly siloed regulatory working groups, but it's become sort of a blended, holistic approach to an entire regulatory space. But also now it's a global practice, and so that's why we are working more than ever with our colleagues in London, in Berlin, in Brussels, in Tokyo, in Hong Kong, Singapore, everywhere that we have a presence to bring to bear our resources to evaluate issues as comprehensively as possible. And so how we think about national security in our group is that we try to assess as comprehensively as possible all the ways in which a government can affect the behavior of persons or companies to further that government's or allied government's foreign policy and national security objectives. So again, it does require an understanding of geopolitical events, cutting edge and historic, and also expertise in various regulatory regimes that predate this sort of convergence of national security concerns, and then that those regimes that have evolved and developed as those concerns have become more pointed. The sliver of national security space that we're going to focus on there during this lunch hour will be related to updates in the foreign direct investment space, again, in the US, the EU, and the UK. But those, it's a very important point that those are not the only regimes. In fact, some of the more dynamic developments have been that how one regime plays off another. So for example, the US regime in CFIUS, things could be going very well in CFIUS, and it could be a low risk transaction there. But if the business has a footprint in China, the regulators in China may feel differently, which is a dynamic that is not new necessarily, but is becoming more of an issue in a far broader set of cases. So that's a bit of table setting on what we think of as global trends and convergence. So we'll move to the next slide, where we'll go into the U.S. government regulatory profile here. And those of you who we met with in person or attended our webinar last year will may recognize this phrase or word that we rely on a lot, which is convergence. And what that means is that it's the convergence of existing tools and existing national security concerns to really focus on a set of very critical issues. And it's impossible to discuss this without focusing on China. The strategic competition with China is the defining geopolitical challenge for the United States, and as much as the United States is trying to get its way for its allies as well. This manifests in a number of different ways. We see it in maintaining a technology advantage in certain critical technologies like semiconductors and microelectronics, quantum computing, biotech and clean energy, and others. And then that has evolved. It used to be that the United States wanted to control what kind of development its competitors would get in certain critical areas like defense and security. But really now it's almost a competition. And that affects how the regulators view transactions in this space. And then the convergence, the notion of convergence is that the U.S. government has this national security and foreign policy objective to further those goals, and they bring to bear all the tools in their toolbox. It's the overused metaphor in this space, is the toolbox metaphor. And so we're going to touch on a number of them, including, of course, CFIUS, and we'll also touch on some very important updates in the export control space on the U.S. side, and also that were thanks in large part to multilateral agreements or changes that Japan and the Netherlands agreed to undertake in the semiconductor space as well. James is going to go into some detail on the so-called reverse CFIUS, which is a bit of a misnomer, but that's still how it's colloquially known. But be mindful of the other tools that are out there, particularly those that affect the supply chain, both in the U.S. and outside the U.S. for companies that feed into the commercial or U.S. government supply chains. This couple key terms that you may recognize is Section 889, the Information Communication Telecommunication Services Executive Order that came out a few years ago from the Department of Commerce, that is really an untapped authority by the Department of Commerce to evaluate anything that might be caught by CFIUS. And then another important area that we're seeing in the news a lot, and major legislation in this area the last few years, is there are things like the CHIPS Act, where the U.S. government is is putting its money where its mouth is to not only defend the advantages it perceives it has, but also to expand or reinvigorate those advantages in certain key areas, like, again, semiconductors. And those guardrails apply generally only to countries of concern, again, namely China in this area. So that's kind of what we mean by this convergence notion, a set of regulatory tools that the US government brings to bear to further its national security objectives. So I think the next slide will be diving into everybody's favorite, and now the granddaddy of them all, CFIUS, on slide 6, I believe. And so just to, sorry, yeah, there we go. So the next 2 slides will talk about CFIUS, and the first one is really just to level set on the jurisdictional reach, and the next one that I'll turn it over to James for is to talk about some of the trends that we're noticing, both in terms of statistics, but also in terms of experience-based trends. And that it's important to, it looks like a redundancy in our slides, but it's important to note that the framework is the same, both in terms of jurisdiction and in terms of emphasis on from a risk perspective. But everything from a jurisdictional perspective to the risk-based analysis is becoming, there's an enhancement, there's an enhanced vigor from CFIUS and the interagency, from the agencies that comprise CFIUS. So I'll go through, bear with me while I go through a little bit of sort of CFIUS 101, just so we're all on the same page about what it is and what it can do, because as you'll hear from Mary Claire and Felix, it's not exactly the same as everywhere else in the world. So CFIUS is and has always been an interagency committee authorized to review certain transactions involving foreign investment in the United States by foreign persons to determine the effect of that transaction on the national security of the United States. And the term that has always been used to describe its jurisdictional reach is over covered transactions. And the traditional form of jurisdiction over covered transactions is where a foreign investor, foreign acquirer obtains control of a US business. Now, US business is extremely broadly defined, and it's even more broadly applied. And control is also broader than the traditional notions of control from a corporate perspective. It's a much lower bar than 50.1% of the voting interest or control over the board of directors. As a rule of thumb, you want to evaluate each transaction on its own facts and circumstances. But when you think about where the control line is, you want to start looking closely at control where you have some meaningful equity position. So 10% is usually the rough line, and the ability to designate at least one director to the board. You can have some transactions that are higher than that aren't control, and some transactions that are lower than that where CFIUS will find control. So the circumstances do matter, but just to give you a rule of thumb on where we start to think about the lines. And then one of the important developments of a few years ago was where CFIUS, where Congress and then CFIUS implemented regulations to expand its jurisdiction over certain non-controlling but non-passive investments in a subset of US businesses. And those businesses are those that the US businesses that design, develop, or produce export controlled technologies, which are called critical technologies in this space. Those US businesses that collect or maintain sensitive personal data on individual persons, and those US businesses that are active in certain critical infrastructure areas like the electric grid or airports and undersea cables and other telecommunications areas as well. And it's important, and it's hard to, it's easy to say this, hard to put in practice some days, especially when you see how CFIUS interprets its authority in some specific cases. But CFIUS really remains an emphasis, reviews transactions and acquisitions for risk to potential national security. It is not for economic security. There still is a line there, although the lines between where economic security stop and national security start are harder to define than they used to be. And then, so unlike some of the regimes outside of the United States, CFIUS remains a largely voluntary filing regime. So the large majority of transactions that are covered transactions, the parties are not required by regulation to notify CFIUS of those transactions. The so-called penalty for not notifying in a voluntary context is that CFIUS retains jurisdiction over the case forevermore. And though, so at any state, 1 year, 2 years, 5 years, 10 years down the line, CFIUS can come and decide it wants to review that transaction after the fact. There is a small sliver of transactions involving critical technology companies in most cases, that the parties are required by regulation and law to notify CFIUS in advance of closing. The penalty for not notifying in the context of a mandatory filing is monetary penalties up to the value of the transaction. And of course, CFIUS retains its other remedies, such as unwinding the transaction that they have and continue to be able to exercise. And James will get into some of the developments in how CFIUS has sort of got its back up on enforcing not only the mandatory filing requirements, but also other areas of its authority. So we'll go to the next slide, and I think I'm going to turn it over to James to talk through the next, and I'll be back on a couple other issues.
Thanks, Charles. And as Charles said, the framework for CFIUS is largely the same, but there is and has been over the last 12, 18 months, an enhanced vigor by the committee in the way it thinks about transactions and the way it goes about its business. And that's been seen through executive actions by the president. President Biden in September 2022 issued the first ever CFIUS specific executive order. It didn't change the framework of the committee. It didn't give it new powers or create new mandatory filing obligations. But what it did do was outline the factors that the committee considers in the course of its analysis of transactions, the things it's thinking about, and certain sensitive sectors. So, for example, things like biotechnology, microelectronics, battery technology, quantum computing. The executive order specifically identified those sectors as of interest to CFIUS and the executive branch at large. The first time we've seen such a public description of things that could be of interest to the committee. And in the same vein, it talked about the more broader themes in the market that it would consider when thinking about a specific transaction. Things like consolidation in the market, what does the supply chain look like, things like that. And in parallel, or I guess maybe a little bit later in the year, the committee published enforcement guidelines. And this has been another topic where the committee has really enhanced the vigor with which it goes about its business. And so as part of a transaction, when the committee reviews it and it identifies a risk, the committee can ask transaction parties to do or not do certain things. And those are called mitigation agreements, and they are incredibly bespoke. So one transaction's mitigation agreement is going to be different from another transaction's mitigation agreement. And it can be something simple like continue to supply the US federal government with something it's currently buying, or it can be very complex, right? Keep certain individuals and the public at large, perhaps, from accessing certain sensitive information. And the enforcement guidelines talk at great length about the conduct that could be a potential violation of a CFIUS mitigation agreement and the way the committee will think about its enforcement or penalty powers vis-a-vis a potential violation. And so we've seen over the last year, the committee increase the number of site visits, increase the number of questions, increase really just the dedicated resources to mitigation agreement compliance. And so, for example, it used to be that maybe 2 years ago, you would have a mitigation agreement and you may not know who your point of contact with CFIUS was. Now, I can assure you, you know who it is within 2 days of executing the agreement. And you know what they're expecting of you, probably for the next 2 to 3 months after the agreement is effective. And that is a sea change, and it shows just how much they care about these agreements. And that's a lot of mitigation agreement compliance issues, and that is a big focus of the committee. But another area where they've increased their focus relates to the timing rules for mandatory filings. So as Charles said, for certain transactions,
That, for example, the technology of the U.S. business requires an export for the foreign investor. There can be mandatory filing obligations. And if there are mandatory filing obligations, transaction parties must file with CFIUS 30 days in advance of consummating the transaction. And mandatory filings in CFIUS are relatively new. Right? They started in late 2018 with the rollout of something called the Critical Technologies Pilot Program, and they've since evolved into the current regime. But what transaction parties had done, from the inception of the mandatory filing obligations, was take or make an investment in a U.S. business that otherwise would have triggered a mandatory filing obligation, but hold the CFIUS jurisdiction triggering rights back until CFIUS approved the transaction. And this had worked well for investors and U.S. businesses for 3-4 years or so. Earlier this year, updated an FAQ that said, no, if you take an equity interest in a TID U.S. business and the rights you're seeking would trigger CFIUS jurisdiction and a mandatory filing obligation, then the timing rules associated with that investment don't start when the CFIUS relevant rights are acquired. Rather, they start when the equity interest is acquired. And so what they did is essentially shift the timing rules for that type of investments forward to the initial investment. And so I think when you're thinking about investing in the United States and the target is a TID US business, meaning it deals in critical technology, critical infrastructure, and sensitive personal data, you want to be careful with the timing rules and to confirm there aren't mandatory filing obligations, because it can really impact the timing, because it would start when the investment is made, not when the CFIUS relevant rights are acquired. And I say that there are ways to work around that rule, though they are a little bit bespoke. Things like debt instruments can still be used to fund first, acquire rights later. But it's something you want to think about very thoroughly before you do it, just to make sure you are not on the wrong side of any sort of CFIUS enforcement action, because that too, like mitigation agreement compliance, is a big subject of CFIUS interest. And I will also say these issues, before the FAQ was published, and I think before the enforcement guidelines were published as well, there were sort of mini roadshows with Biden administration officials, right? So political appointees of the federal government talking to transaction parties, market participants, lawyers about the issues that they were seeing, how they were perceiving them. And so the updated FAQ, the enforcement guidelines, the executive order, kind of outflows of that process and that increased vigor. So I think with that, we can move to slide 8. And so every year, CFIUS publishes an annual report, and the information is always a little bit stale because it's about maybe 6 months later than you'd want it to be for it to be really actionable information. But there were significant takeaways from last year. I think broadly, the committee over the past year, and I think we felt it continuing into 2023, has become less efficient. So 57% of notices are moving into investigation. So the process is taking longer. More notices are requiring mitigation. 23% of notices required mitigation agreements in 2022. And then I think more generally, the process has slowed. So it's taking longer for the committee to start transactions. For notices, the process involves submitting a draft first, receiving comments from the committee, and then submitting a formal notice. That initial comment phase from the committee is taking longer. And for the declarations process specifically, there was a time when the declaration, when it was filed, and you could feel pretty confident it would start within 3 business days, right? So if you filed it maybe on a Thursday afternoon, you could know it would start by the next Tuesday. Or if you filed it on Monday, you could feel pretty good that it would start on Thursday. We've seen that process lengthen into, I think it's over 5 business days. And I suspect the real number currently is a little bit longer than that too. And that, along with the declaration process outcomes kind of trending in the wrong direction, has led to declarations being a less appealing option for filers. And just maybe to step back a little bit, the declaration process, it's the short form CFIUS filing. So it started as a 5-page PDF. That's still largely what it is. It takes days, not weeks, to put together. Compare that to the notice, which is maybe a 30-page Word document, much longer, much more intensive. At the end of a declaration period, at the end of a declarations process, its assessment period, the committee can take no action, it can approve the transaction or request a full notice. And what we've seen, fewer transactions are clearing, more requests for notices, and more take no action letters. So it's become a process that's taking longer to start and producing less desirable results. And this isn't combined with just seeing an incredible amount of scrutiny for certain investors, such as sovereigns, and then also even passive, small, limited partners, if they are from countries of interest to CFIUS. So if you think about strategic competitors to the United States, China, Russia, things like that, they will have been generating interest even in very, very small investment amounts because of the nature of the investor. I think with that, we can move to slide 9, and I'll turn it back to Charles.
Thanks, James. So I want to pivot a little bit here because it is only because it is a significant regulatory development in the cross-border space, and this is to talk a little bit about the continued expansion of export controls, and that's the focusing on the U.S. export controls, though it is a global trend again, and Japan is included in that, especially in the semiconductor space. And I want to frame this discussion not so much to give you the blow-by-blow of the most recent technical changes to the U.S. export control regimes, though they are important. And if you're in that space, you do need to have someone that gets to know those regulations in fairly granular detail. And we've sort of summarized the key takeaways on this slide, but I want to frame this discussion, since we're focusing on cross-border transaction, about what this means for certain transactions in ways you might not have thought about it previously. And so the nature of these changes, and in about a month ago, the Department of Commerce issued another set of interim rules and final rules that finalized interim rules that were issued in October of 2022. And so this is really a continuation of a clarification, expansions, and refining the rules that were imposed and had a profound impact on the global semiconductor space last October. And this will be a continuing trend. The Department of Commerce has said that they're going to revisit and continue to refine these controls on at least an annual basis. And so that's a little unusual for the Department of Commerce to go ahead and preview those kinds of forthcoming changes. And so when you think about a regulatory space like export controls and cross-border transactions, trade compliance has always been an important but sort of regular feature of diligence when you're diligencing a target about its compliance with regulations, and you always ask questions about compliance with trade controls, whether they be export or import or other international trade obligations. And that continues to be an important focus. And in fact, it's more important than it ever has been because, at least in the United States, the Department of Commerce and the Department of Justice are in an enhanced enforcement posture. Earlier this year, the Department of Commerce issued its largest ever civil fine against a Singapore affiliate of a U.S. company in the semiconductor space of $300 million. And then, so diligence remains an more important feature here. The other thing I wanted to mention is cross-border transactions. Is this can affect the business thesis, the thesis of a business transaction, because even if you're dealing with two non-U.S. parties, where you have let's say you have a Japanese target or a Japanese entity that's selling a facility, and it relies that the nature of U.S. export controls now, especially in the semiconductor space, is that jurisdiction applies to almost any foreign produced item. And so if, for example, there's a Chinese buyer of that facility, you need to really look closely at how and under what conditions that acquirer would be able to have access to that technology, that equipment, that facility, and how that impacts not only the timing and closing conditions for any transaction, but also whether how it impacts closing certainty at all. And so I'm not going to go through these key takeaways one by one, but I do want to draw, in addition to those sort of thematic points about how export controls can really affect the thesis of a transaction, I want to draw your attention to the last bullet here, which is the controls are coming on infrastructure as a service models. And so if you're either a service provider or a user of software as a service or infrastructure as a service or computing as a service, it has all sorts of different terminology, but basically it's using high-powered compute on a cloud-based system where you can access a high-powered computer and AI models to generate and train your systems. That's a big focus of the United States government, a big concern about access to those models. Those heretofore have not been subject to export control jurisdictions, giving some nuance in how that area is developed. But that looks like it's going to change. And so if you're in that space or interested in transactions in that space, it's a development worth keeping an eye on over the next 3, 6, 9 months about what kind of controls are going to be on just in that really high-powered supercomputing space. And so that's what we wanted to focus on export controls just briefly, and then I'll turn to the next slide. And I think we have about 8 or 9 more minutes on our US side, but I just want to emphasize one of the pitfalls that clients have is that they think export controls is everything, both from a regulatory space and for CFIUS, and that as long as I confirm that the target's technology is not controlled under US export control, I'm clear of CFIUS, I'm clear of national security concerns, and that's just not the case. And that's the point of this this next slide, is to highlight some of the areas that the US government and other governments are concerned about. And I won't read them to you, and you won't be surprised by many of them. We've mentioned several of them already. But the takeaway here is that even if the technology of the target company is not controlled under US or other export control regimes, you need to think about, are they critical technologies as defined in the CFIUS executive order, in the OSTP White House release from February 2022? Are they in the statute as critical technologies, emerging technologies? Because in many cases, like the Department of Defense, for example, will be more concerned about technology that it feels is critical, but is not yet controlled under export control laws. So really want to stress that if you're in this space, very important to evaluate what the technology is from a end-use application-based analysis rather than just a strict regulatory analysis under export controls. James, I think I'm going to kick it back to you for a good 6 or 7 minute summary of the outbound rules.
Thanks, Charles. And before I dive into the outbound rules, we did get a question regarding safe investments in a TID-US business and whether that could potentially trigger a mandatory filing with CFIUS. This is actually a really interesting question. I think it's a great question. And the answer is it really depends on the nature of the safe. And so, for example, if a safe is conveying with it on execution some sort of CFIUS relevant right, then it certainly can. And so what we've seen in the past, maybe sometimes you'll have a simple agreement for future equity, and it has along with it maybe like a board observer seat or some sort of right in the target company that would be either quote unquote control for CFIUS purposes, or in the case of a TID-US business, a CFIUS relevant right, meaning a board observer seat, a board seat, certain rights to technology, things like that. And so they certainly can. And for the ones that, and for this, the agreements that do convey CFIUS relevant rights, it becomes an interesting question where you are almost forced to do diligence initially, right, to understand what the US business is. Is it a TID-US business, or is it the type of business which could trigger mandatory filing? And then again on conversion, right, because your rights are going to change in the future to something else, and those could be CFIUS relevant. And then you need to know again, what is the US business? Has its technology changed? For example, in the battery context, sometimes when you're working to make a better battery, if you check in on a company a year later, the efforts to make a better battery are in some ways efforts to drive towards technology that becomes export controlled. And so those are the issues you run into with safes. And it was a really good question, and thank you for asking. And so with that, I'll dive into the outbound investment program. And so we've talked a little bit about the tools that governments use to impact transactions. The outbound investment program, quote unquote, reverse CFIUS, is the newest. It was been anticipated for, gosh, it seems like a year or so, but it was rolled out in this past August in two parts. So there was a high-level executive order from President Biden outlining the broad contours of the program. And then in parallel, there was an advance notice of proposed rulemaking that outlined some details and then asked a lot of questions to impacted parties. And so the key takeaways maybe of this two-part theme, there was no immediate impact. So capital flows from the United States were not immediately regulated. There weren't new diligence requirements overnight, but we know they're coming. And we know the executive branch, the Biden administration, has thought long and hard about what these requirements could look like. And I think we'll see maybe late first quarter next year, the draft regulations, which should give us a good feel for the way these things will be when they become final and effective. So if we move to the next slide, we'll talk a little bit about the program structure. And much like CFIUS, it can be boiled down to three parts. There's a U.S. person, there's a transaction, and then there's entities engaged in certain conduct that meet certain other requirements. And so this is where I think the reverse CFIUS comes in. It's a U.S. person making an investment in a covered entity. And the U.S. person definition is very broad, right? So it covers entities organized in the United States, entities in the United States, U.S. citizens, but it also includes entities that may be organized outside the United States, but in which U.S. persons hold significant roles. And that's something that I think transaction parties will need to track, right? It becomes a new requirement. You need to understand, for example, the citizenship of the people who control the investments you make, your board of directors or CEO, things like that. The transaction definition is a little bit more knowable. There are lists of things. There are carve-outs for example, like public company passive type transactions, things like that. The federal government focused much more on transactions that convey some sort of additional value to the party, right? You think about like know-how, business know-how, things like that. And then the smallest element, which I also think is the hardest to really diligence, is an entity located in or subject to the jurisdiction of or under the control of PRC entities, right? So think that's Chinese nationals or Chinese entities, and engaged in activities related to a certain defined set of subsets, a defined subset of activities and technologies. And there are two things that come into play. There are prohibitions on certain high-end semiconductor design, manufacturing equipment, things like that, as well as a prohibition on investments in certain quantum computer companies, things like that. And there was not, and it was reported throughout last year, prohibitions or things related to artificial intelligence. If you move to the next slide, you'll see that there's a targeted, no broad prohibition on AI, rather prohibitions related to potential end uses. And then there are also a lot of questions, right? You talked about questions in the advance notice proposed rulemaking, a lot of questions about the technology and how it relates to AI. And so I think what we'll see notifications related to artificial intelligence. How those play out, I think, is perhaps the most unknowable aspect of this program, because there were a lot of comments given in response to the proposed rules, and we'll just have to see how those shake out next year. And so with that, I'll turn it over to Felix for his part.
Thank you, Stan, Charles, and James. We'll now turn to the developments in the European Union, EU FDI. When we move to the next slide, we'll start with a quick recap on what we already discussed last year when we met in Tokyo. As you may know, the EU governs FDI screening at a EU level only in a framework context, but the member states remain responsible to screen foreign investments and to decide about the applications that are sent in. And that has remained that way. And what we see is that the number of member states that have a screening mechanism increases year over year. So the number of regimes you would have to take into account when thinking about an investment into the EU is increasing, and there might be filings triggered in one or more member states. It's not an aggregated a one-stop shop regime. And you will see at the member state level that other government agencies and bodies are involved. So it's not just one authority. It's not always a committee like we learned just for the US, but it might be cooperation between ministries. And the same applies at the EU level. The EU Commission will get involved under the EU cooperation mechanism. So it's a pretty complex and multilateral process once you kick foreign investment screening off in the EU. And generally speaking, the trends we've just learned from the US side are similar in the EU in terms of convergence of FDI and other tools governments use for protecting national security. It's not always as advanced already as in the US, but there are certainly policies and trends already around here, and we'll come to that shortly. Next slide, please. So to reflect what has happened in the past year in terms of more regimes coming into effect across the EU, the drivers have been still the same: more protectionism, protection of critical infrastructure, supply chains, and technology sovereignty. It's still also a consequence of the pandemic when we look at the healthcare sector to protect more the supply chains in that area. Of course, the war in Ukraine is critical here, and supply chains have been disrupted. So there's another need to protect those. And then there is the US-China trade tensions, where Europe sits in the middle, and policies have to be adjusted in that regard. Currently, there are still some member states that are about to adopt a new FDI regime, so it's not yet the full 27 member states having a regime in effect, but we are close to that because everybody is now at least working on a screening regime. We have seen new regimes in 2023 coming out in Luxembourg, a broader regime in the Netherlands, entirely new one in Belgium and Estonia, for example. And others have been revised to broaden the scope, for example, in Denmark and Spain. And we are not there yet. Just on 1st of December, we will see an entirely revised and new broadened regime in Sweden. And we may still see changes to the French regime this year. And next year, other member states will again think about revising and adopting new regimes. So this is an evolving process, and the multilateral FDI analysis has to take all these developments into account, and filings may be triggered in one or more of these jurisdictions within the EU. Next slide, please. Just to provide some examples, what might be in those revised regimes if member states decide to change the law. It's still a mechanism of adding new sectors that could trigger a mandatory filing. For example, France is planning to issue a new decree that would add the critical raw materials sector into the mandatory field. It's also in terms of whether only entities or also branches could trigger a nexus that would give jurisdiction, and France is thinking about making more clearly that French branches are sufficient, so not just a local subsidiary would trigger the FDI regime there. And for example, in Germany, there might be major changes next year because the government has started to think about adapting a new investment screening act and putting all the rules that are now in place together in one new law. And that would come with a number of changes, including restrictions on potentially restrictions on IP transfers that are currently not caught, or greenfield investments that are also currently not screened. There may be also changes in the definitions of certain mandatory sectors as they are now in the law. For example, regarding artificial intelligence, that the government believes is too narrow currently. So this may be broadened. The same for robotics and other critical technologies. There might be changes to the filing thresholds, some atypical situations of control or voting at annual meetings may be subject to foreign investment screening if this new proposed law comes into effect. And there are a couple of procedural and timelines related changes we would expect. And for the first time, there will be filing fees applied in Germany as well. Next slide, please. This slide just shows how much screening has taken place in the past year. Also, the EU Commission and national member state authorities issue like annual reports, and we see overall an uptick in the number of screenings and the number of filings, and that is of course related to the fact that there are more and more regimes implemented throughout the EU. And I would just want to point to the fact that while there's a lot of screening going on, it's still not that this means all the transactions that are being reviewed will be prohibited or mitigated. Most of the applications just go through and get cleared quickly. Next slide, please. To summarize the trends, we have some blocking decisions that came out in the past year, for example, in France and Denmark, and there are a couple of others. And most of them still relate to Chinese investments into the EU, but there are some that may also concern other investors. In France, there was another decision against a US investor. It was an indirect investment into France that I want to mention here, just to show that there might be situations where even investments from allies could be caught and mitigated or even prohibited. And in Denmark, it was a Japanese investor, but these were very specific circumstances. And reportedly, the buyer has refiled the application. So this is not the last word, probably. And we also see the first court decisions. The CJEU, the Court of Justice of the EU, has issued a decision where it dismissed a blocking decision by Hungary because the member state just went too far and prohibited an investment that was not where there was no need to block, and it was against the European law rules of freedom of circulation of capital, and it was dismissed. There are many policies that go into the direction that the US team already mentioned, where national security strategies are adopted at the member state level. For example, the first one in Germany or China-specific strategies, and at the EU level also governing foreign subsidies and then recommendations on which technologies are critical and should be taken into due consideration by the member states. Next slide, please. Just to wrap this up, this high-level overview of the EU trends, we see many Japanese investments in the EU. It's one of the 6 top investors, and these investments are normally seen very positive and very likely to be approved. They are very welcomed, and only sometimes we see commitments being requested. And as mentioned, there is this one first prohibition case under very specific circumstances, but that is not a general trend. And investors are still seen very positive, and it's a case-by-case analysis for every investment. With that, I'll hand it over to my colleague Mary Claire in the UK. Thank you.
Thanks, Felix. So I'm just going to spend the next just under 10 minutes giving an overview of the UK's national security regime. Now, before I start, I want to mention that we've actually just yesterday had an announcement from the UK government. They are conducting a review of the regime and consulting on some potential amendments, including to narrow the scope of the regime in some places. Now, it's very early days in that process, and it's not clear to what extent that's going to lead to any major changes, especially under the current government, as we are in sort of coming up to a general election in the UK, as many of you may be aware. But I will, as I go through, call out some of the points that have come out of that consultation. And this is, as it's quite hot off the press, it doesn't feature in our slides, I'm afraid, but I will call out the relevant points as we go through. So just a quick overview of the UK regime, a quick reminder for those of you who are familiar with it. It's still a relatively new regime, and it's only been in place for 2 years. And in short, the regime is really premised on an extremely broad, what we call call-in power from the UK government. And that relates to any acquisition of an interest in a UK company, including a minority shareholding, or the acquisition of assets having nexus to the UK. So that's extremely broad. But then within that, we have a subset of transactions which require mandatory notification before they can be implemented. And that applies only to share acquisitions crossing certain thresholds, where the entity is carrying on activities in the UK in one of 17 sensitive sectors. And that includes many of the same sectors we've been talking about and the ones that Charles pointed out, and those that you would expect to see, for example, artificial intelligence, semiconductors, and critical infrastructure, just to give you a few examples. Now, for those transactions not requiring a filing, but that might be subject to that call-in risk I talked about, there's an option to make a voluntary filing. And there, the process is largely the same as that we go through for mandatory filing. And the government has broad powers to impose remedies to mitigate national security risk. And at the extreme, that can include orders to block or unwind transactions. And we're going to come on in a minute to talk about what we've been seeing by way of interventions under the regime. Finally, and everyone always gets a little bit scared by this, but the regime is backed by criminal penalties, including fines and theoretically at least imprisonment for responsible individuals, as well as transaction invalidity for failing to notify. We certainly have not seen any criminal enforcement yet under the regime, so that's largely there for a deterrent effect. In terms of when the regime applies, the mandatory filing requirement is relatively narrow, but it is important to remember that the regime in the UK captures a really broad range of transactions, and that includes, at least for the moment, internal reorganizations, and that's something which comes up quite a lot. We end up having to make filings for clients on a regular basis for those kinds of transactions. Now, I'll just pause here to note that in the announcement yesterday that I mentioned, the Deputy Prime Minister in the UK has stated the government is considering whether to introduce exemptions from the mandatory filing requirement for certain situations, and that includes internal reorganizations on the basis that these, as you might expect, often do not give rise to any national security risk. Now, this is a significant change in approach because the government was very deliberate and clear about wanting to have internal restructurings in scope of the regime when it was implemented 2 years ago. Now, it remains to be seen whether that exemption will actually be agreed. It does require parliamentary approval. And as I said, we're about to head into an election, but interesting nonetheless that that is something that is being currently proposed. Now, whilst I'm on the subject of that review, I'll also mention that the 17 mandatory sectors are also now being reviewed as part of that process. And what we expect to see coming out of that will be a new set of regulations to grapple with. That is aiming both to clarify and narrow the scope of certain sectors. So there are, the main one being called out at the moment is artificial intelligence, where there are the sector's been drafted quite broadly and is capturing businesses that don't raise any national security risk. But there's also going to be some expansions to certain of the sectors, and I think some recategorizations to more clearly capture certain sectors that are of acute interest, in particular semiconductors and critical minerals, really just kind of repackaging those. So if we go on to the next slide, please. Just a few quick words on defining national security risk. So the headline here really is that this is deliberately not defined in the regime to give the government maximum flexibility. And the only real guidance that is given is a sort of explanation of the framework that the government applies when thinking about national security risk, and we've set that out in the slide for reference. Now, this is another area where we're actually expecting to see more detailed and informative guidance coming out of that consultation process, because the government had promised that they will do that. Now, in the meantime, what we can glean from the cases that are coming through the process is a sort of set of concerns set out on the right-hand side of this slide, and that includes, which is where the investor is coming from a hostile state and acquiring sensitive technology, where there are concerns around transfer of capabilities or technology out of the UK, or where the transactions concern critical infrastructure or critical supplies to the UK government. If we could just move on to the next slide, please. So this slide gives you an overview of what we have been seeing by way of intervention since the regime came into effect. And as I said, it's been just nearly 2 years. It'll be 2 years in January. We think there've been somewhere in the region of 1,500 filings. The vast majority of those have been cleared without any detailed investigation. And for example, in the last year, the rate of clearance was 93% reported by the government. But there have been a total of 17 cases in that period where there have been remedies. Of those, 5 involved complete prohibition or unwinding of the deal. 4 of those 5 cases involved Chinese investors, again, which of course is notable and consistent with what we've been hearing about other regimes. We also set out here an overview of the remedies that we're seeing, and there you can kind of observe a range of measures really falling into 2 broad categories, which are ensuring oversight of some kind by the government, or measures to protect sensitive information, technology, or strategic capabilities from being transferred out of the UK. Next slide, please. So just a few more statistics, just showing the trends around called-in transactions. The first chart here on this slide shows the nationality of the acquirer involved in call-ins. And that does just illustrate that the UK regime is country agnostic. So you can see there even are transactions with UK acquirers being scrutinised under the regime. But of course, you kind of see also a high proportion of publicly known call-ins focusing on Chinese investors again. We're showing also here the sectors, and you can see technology, of course, standing out as a key sector of focus, which again is not surprising. And then finally, the type of transaction, where it's worth noting that, you know, while the majority of cases involve controlling share acquisitions, just under half of the cases being looked at actually involve either minority shareholdings or asset acquisitions. And then just the last slide, please. Just a few remarks in relation to recent developments. And of course, I've given an overview of the most recent government consultation announced yesterday. Another significant change which occurred earlier this year was to move the Investment Security Unit, which administers the UK regime, to sit within the government's Cabinet Office. Now, this had the effect of making the decision maker the Deputy Prime Minister, who is clearly closer to central government. Now, there is some speculation that was intended to rein in the regime due to concerns that it was having a chilling effect on investment, and that rhetoric is certainly continuing with the most recent announcement of the Deputy Prime Minister. I'll stop there and hand over to Stan just to do the final 1 minute of admin wrap up, and thank you very much for your time.
Marie-Claire, thank you. And thanks to all of our presenters. We appreciate everybody joining. Very interesting. Thanks to our attendees. Appreciate you taking your lunch hour to join us for this discussion, and really hope it was interesting for you. If you have any questions about anything, then please don't hesitate to reach out. You can reach out to me or directly to our presenters. Either is fine.